On the privacy corner, the European Commission has issued its first ever enforcement decisions under the Digital Markets Act against Meta and Apple. Does this have implications for consent or pay models in the EU? Not necessarily. We'll look at the detail on that. Loss of availability. Is that or is that not a personal data breach under the GDPR? The ICO in the UK thinks so, and it fined a data controller £60,000 for failing to report loss of availability on time. A complex, inflexible and inconsistent procedural nightmare. This is how Max Schrems describes the upcoming GDPR procedural reform. So we'll see what his issues with that are. Now, first up then, the Digital Markets Act. The Commission has issued two penalties against Apple and Meta, 500 million euros for Apple, 200 million euros for Meta, and this is all about, well, the DMA. It is targeted at large online platforms called gatekeepers. It's kind of a quasi-competition law type thing. It is designed to encourage interoperability. It regulates the use of data processed from or combined across services. It encourages fair access for businesses operating on gatekeepers' platforms. It's all about consumer choice, anti-steering, and so on. Now, the context here is that these investigations began last March when the DMA took full effect. There is also one against Google. The Commission gave a preliminary decision last month to Google, not looking good, but we'll check back in on that when it's finalised. First, let's look at Apple's DMA violation. Now, this one has more to do with competition, antitrust stuff than privacy. Essentially, the Commission found that they were not giving developers sufficient freedom to signpost or steer users away from the App Store. So for in-app purchases, Apple kind of wants to force developers to make users pay for things within the App Store so that Apple gets a cut. The Commission thinks developers should be allowed to steer people away from the App Store to encourage more competition and so on. So it's a 500 million euro fine for Apple there, and in order to do that better. Meta, their violation is around consent or pay. So essentially since November last year, well, for a long time, it all goes back to 2018. Meta has been playing legal basis, kind of musical chairs. Not sure if the Americans among us will get that reference. Switching around from legal basis to legal basis, trying to satisfy its shareholders and various EU institutions. Now, the Commission found that the type of consent or pay Meta had implemented between November 23 and November 24 violated the Digital Markets Act. This had a binary choice. Either you consent to targeted ads, and those targeted ads, by the way, involve data from across Meta's various platforms, or you pay a subscription fee. The Commission says this is not good enough. Under the DMA, you'd also need to give a third option, which is less data intensive, but also free. Now, Facebook and Instagram have since implemented such a model. So this is a retrospective decision. And does it kill consent or pay? No. This specific decision does not imply that consent or pay is illegal in the EU per se. It's pretty specific to large companies, gatekeepers under the DMA. Most companies are not gatekeepers. Also remember, this is a retrospective decision, so it refers to a specific time period that has expired. And Meta introduced a new model with that third option, partly in response to the EDPB's pay or consent opinion, perhaps more so in response to this Commission investigation. So it could be that this new model satisfies the Commission. They're currently investigating it. We will, of course, keep you posted on this very long and complicated consent or pay battle with Meta and the EU. So next up, the ICO has fined a law firm, DPP Law Limited, £60,000. So that's around $90,000, I guess. The violations of the UK GDPR, specifically security failures and late data breach notification. So The core issues here are that an old admin account with excessive privilege was compromised, and there was a ransomware attack. And well, let's get into the details. So DPP law handles some highly sensitive data, criminal defense evidence, some family law stuff, and the weak link in their network security was called SQL user, a SQL user, an admin account that was created over 2 decades ago by a third party. It had broad, unnecessary privileges to DPP's network. Not the least privilege principle was not applied here, allegedly. And this account remained active even after DPP migrated to a new system in 2019 and lost support for the old system and that admin account in 2021. So in 2022, February, someone started brute forcing this SQL user account. So they were targeting it with random passwords trying to get in. They succeeded on the 3rd of June. That account was compromised. And on the 4th of June, the attacker used that account to disable DPP law's security restrictions and backups. So this is essentially a type of ransomware attack, it seems. And DPP discovered this attack when they found they could not access their email accounts or network in general. And the problem was that they did not detect any data leaving their network. The firewall was not set up to log egress flows, so data going out of bounds from the network. So what they didn't notice was that someone had stolen a bunch of their data. Not only could they not access their devices, they also had lost a lot of data. They only found out when the UK National Crime Agency notified them that 32 gigabytes worth of their stuff was available on the dark web. This is really sensitive documentation. We've got evidence, court, expert witness accounts, and DPP reported the breach to the ICO 2 days after the NCA got in touch. So that's 43 days after the initial compromise on the 4th of June. So outside of the reporting window here, allegedly. So the ICO found violations of 2 types. Firstly, security. So Article 5.1F and Article 32. So this account basically had far too broad access privileges. It hadn't been risk assessed. There was no MFA. So it was an accident waiting to happen, really. This very broad privileged account with no MFA and no risk assessment was sitting there waiting to be hacked. Secondly, the notification failure. So this is under Article 33 of the UK GDPR, which says that you have to notify the ICO of certain data breaches within 72 hours or without undue delay. And DPP said they misunderstood this and that they were focused on fixing the problem rather than contacting the ICO. Now, does loss of availability actually trigger the data breach reporting obligation? There has been some debate about this on LinkedIn. The ICO's stance is firmly yes. They clearly consider loss of access or loss of availability of personal data to be a breach. That can happen as a result of ransomware. But looking at the definition in the GDPR, we only see the word loss. The ICO takes this to incorporate temporary loss of availability rather than just loss per se. They even have an example, pretty much what happened to DPP on their website. So whether you agree with their interpretation or not, the ICO, if you're in the UK, is likely to be the first body you come up against if you have a data breach like this. So just bear in mind that the regulator does consider this to be a reportable breach, even at the point where they just lost access to their systems. Next up, privacy group NOYB has slammed proposed EU law reforms meant to improve GDPR enforcement. They say it will make it worse. They call it a complex, inflexible and inconsistent procedural nightmare. And they are sounding the alarm about this upcoming legislation. So this is called the GDPR procedural regulation, very inspiring name that they've given it in the EU. And the idea is to create a consistent, strong data protection enforcement regime across the whole EU. So the GDPR, the whole point of the GDPR was to harmonize these things, but in reality, people in different EU member states have very different experiences of making GDPR complaints. So the Irish DPA, for example, handling complaints against big tech has been criticised, and some, for example, in Spain, they issue a GDPR fine every day, it seems, small ones against small businesses. So the idea is to unify all this under one harmonised procedure and make things easier and simpler and clearer for data subjects and for businesses and other organisations. Now, the NOYB has produced this chart showing how complicated they think this will make things. It's, according to them, gone completely wrong. It will be inconsistent. So instead of one clear process for making a complaint, there could be 10 different procedural pathways. So that's less clarity rather than more clarity. They also heavily criticised the data subjects being kind of cut out of the process, allegedly, losing their right to be heard early on in the complaints process. They say there will be long delays under this new arrangement. The council is pushing for deadlines of up to 33 months to resolve complaints rather than the 3 to 9 months suggested by Parliament, and just generally less legal certainty, more clashes, difficult interplays with other laws. NOYB is not happy with how this is going. So the next step, I mean, it's in trilogue at the moment. So this is the GDPR procedural regulation, not the reforms for SMEs that we've also seen in the news recently. NOYB is sounding the alarm about this in the hope that there will be reforms before the law is finalised. So thanks so much for your time and attention this week. Thank you again to Privado AI, and I'll see you next time.